Hello everyone. In this video, I'll be talking about the ideas or the concept of judicial activism. While dealing with this concept, I will be very briefly touching upon the ideas of judicial review once again. Do you know that the Supreme Court of India during the tenure of 1950 to 1971 failed to promote and uphold and established the ideas of social justice with democracy as envisaged in our constitution? We all know the importance of part 3 and part 4 of the constitution. We also know the difference between part 3 and part 4. Part 3 is a set of guaranteed rights available against the state, and they are enforceable, justiciable. Part 4 rights are not justiciable. There is a dearth of resources. Nevertheless, the rights, the directive principles of state policies in part 4 are very fundamental in the governance of our country. Do you also know that it is the parliament who represents the will of the people? They fought the elections and they represents the will of the people. They represents the aspirations of the people in the parliament. And it is not the judiciary who fought the election, and therefore, while protecting the rights of a particular community, judiciary, higher or lower, they cannot come in the way of the parliament. This remark was also made by Pandit Nehru, the first Prime Minister of independent India, that judges should come down from the ivory tower to sympathize with the cause of the legislatures, which had to do 1,000 more important works needed urgently by the deprived category of the society. The judiciary till Goloknath case, till 1966, did not adopt a very liberal or a progressive outlook and declared property as a fundamental right. And since property is declared as a fundamental right, therefore it is beyond the reach of the parliament. Judiciary used the power of judicial review in Goloknath case, and also held it that the power to amend the Constitution of India should be found in the words of Article 368. But Article 368, as it stood then, deals only with the procedure to amend the Constitution, but the power to amend the Constitution was absent. And therefore, judiciary discovered that the parliament have made amendment to the Constitution with the help of an ordinary law. That is, ordinary law is not an organic law. That means that the parliament have amended the Constitution and by using Article 13 of the 13, and any law which is not an organic law have to be detested against fundamental rights. But here the surprising object is that Article 13, the primary object of Article 13 is to secure the paramountcy of the Constitution in regard to fundamental right. Let's see how Article 13 reads. The first clause of Article 13 deals with the pre-constitutional laws and declares all the pre-constitutional laws as void to the extent it is not consistent with the fundamental rights. The second clause of Article 13 deals with the post-constitutional laws and prohibits a state from making a law which either takes away totally or abrogates in part a fundamental right. So the idea of Article 13 is to protect the paramountcy of the Constitution in regard to the fundamental rights. The court in Goloknath case was divided in the ratio of 6:5. Now the majority was of the view that there was no any distinction between a legislative power, legislative and a constituent power of the parliament, and as such the constitutional amendment was a law within the meaning of Article 13 clause 2. And in Goloknath case, not only the 17th amendment was challenged, also the first and fourth amendment was also held invalid. Now since judiciary have discovered that all the amendments the parliament have done till Goloknath was with the help of ordinary law, with the help of Article 13. Therefore, judiciary can, in one stroke, judiciary can strike down all the amendments that took place till 1966. But judiciary did not have such an attitude of humiliating the other branches of the government. So very wisely judiciary brought the doctrine of prospective overruling, and through this doctrine all the other amendment that took place till 1966 was saved and it will be prospectively overruled. So this was indeed an innovation. Justice Subbarao in this connection, Justice Subbarao in this case declared that Parliament will have no power from the date of this decision to amend any provision of Part 3 of the Constitution, so as to take away or abridge any fundamental rights enshrined therein. Now take note of this, that judiciary here till 1966 is very much interested, or judiciary is protecting the property oriented interest. Judiciary is somewhat not very progressive, or judiciary is somewhat not interested in bringing the ideas of social justice, because if property is declared as a fundamental right, the tillers of the soil will never be able to come to a position to own a plot of land. The land or the soil which they till, they will not be able to own. Ownership will not come to them. So property was a fundamental right till that point of time, and the same approach was taken by the judiciary even in bank nationalization case and also in privy purses cases. But the judiciary made it clear that Article 368 consists only of the procedure. The word power is absent to amend the Constitution. So take note of this, that the tussle between the legislature and the judiciary is going on and on. So the Parliament, by 24th Amendment, they have no other choice, have to respond to the judiciary that they have the power to amend the Constitution. So the Parliament, by 24th Amendment, amended Article 368 and substituted the word power for the word procedure to amend the Constitution, and also amended Article 13(4), also amended Article 13 and inserted Clause 4 to Article 13, and to place Article 13 beyond the power of judicial review. Now, with this 24th Amendment, uh, so far the power of judicial review is concerned. Now the court will have to bow their head to the parliament. The attitude of judiciary while bringing the doctrine of prospective overruling did not have an attitude to humiliate the parliament, because they never attempted to strike down all the earlier amendments which was done with an ordinary law. But here the parliament have an attitude to strip out the power of judicial review from the judiciary. So far the power of judicial review is concerned. Now the courts will have to bow their heads to the parliament. Judiciary again did not bow their heads to the parliament and brought out another innovative doctrine, the doctrine of basic structure, in the case of Kesavananda Bharti versus State of Kerala. And it was only in this case, that is in Kesavananda Bharti case, that the directive principles underwent a metamorphosis, and the court is no longer opposed to social change or the ideas of social justice by overreacting to the ideas of fundamental rights. So the true position after 1974, or the true position after the Kesavananda Bharti case, is that every provision of the constitution can be amended, including the fundamental rights, provided the basic structure of the constitution remains the same. And what is basic structure? Now basic structure is not the fundamental rights. Till Goloknath case, the attempt of the judiciary was to keep the fundamental rights protected from the reach of the parliament. But after a gap of several years, from 1966 to 1973, every provision of the constitution can be amended, but the basic structure will not be amended. And any attempt of the parliament to abrogate the basic structure, the judiciary will have no other option but to strike it down. So the tussle between the legislature and the judiciary is on and on. In response to the innovation of judiciary's basic structure doctrine, the Indira Gandhi government took a very powerful decision and declared emergency in the year 1975 and suspended Article 14, which deals with equal protection of law, suspended Article 19, which deals with the freedom of speech and expression, and also suspended Article 21, which deals with right to life. Now, if we again emphasize on the wording of Article 21, it reads as, no person shall be deprived of life and personal liberty except according to the procedure established by law. And this was indeed a great opportunity for the judiciary to interpret whether procedure established by law is a state-made law non-conforming the principles of natural justice, whether life is a gift from the state, or life is an inalienable concept of the people. The judiciary could have used the power of judicial review also, but instead of using the power of judicial review, or instead of protecting the civil liberties of its citizens, what judiciary has done is that judiciary upheld the suspension of the top leaders during the emergency period. It has put behind the bars the student leaders, the advocates, the human rights advocates, and sadly judiciary miserably failed in protecting the civil rights of the people. It was only when the emergency was lifted in the year 1977, when the Janata government came in power and swept away the Indira Gandhi government. This gave a lot of impactors and a lot of courage and a sense of realization to the Supreme Court that so far they are as a branch of the government. They are independent, and it is on their shoulders that it is entrusted to protect the spirit of the constitution. Now they started a new era. The judiciary started a new era of judicial activism, and so far they are concerned. They not only feel, they also show that they are completely independent. And judiciary give rise to a new remedy, the remedy of public interest litigation. The credit of PIL goes to Justice Krishna Iyer and Justice P.N. Bhagavati. This concept of PIL revived and renewed the hopes and faith of the poor on the judicial process. The person who is victim need not need to come to the court, but the deprived people, section of the people, or the deprived person can also approach the NGO, and they can write letters to the judiciary, and the judiciary will hear them. Those letters were treated as writ petition, and the judiciary will hear them and give directions to further the cause of justice. So likewise, we have many case laws where public interest litigation was really a boon for the downtrodden section of the people, like Hussein Ara Khatun versus State of Bihar, where the Supreme Court freed a number of indigent under trial prisoners who were confined or languishing behind the bars beyond the period, because they were too poor to furnish bails. Likewise, in the case of Sunil Batra versus Delhi administration, where a prisoner's letter was treated as a writ petition. In another case of Sheila Borse versus State of Maharashtra, a letter written by a journalist alleging custodial violence of women prisoners in jail was addressed to the Supreme Court. That letter was treated as a writ petition. Supreme Court took cognizance and issued directions to the concerned authority. Likewise, this era became a period of activism and thus broadened the framework of human rights. Different jurisprudence like Dalit jurisprudence, gender jurisprudence, environmental jurisprudence, consumer jurisprudence, medical jurisprudence, and many more emerged, where judiciary became the protector of the rights, for the rights of its citizens. Again, if we look to the Constitution, Article 142 is a superpower to do complete justice. Article 142 talks about enforcement of decrees and orders of the Supreme Court, and this is indeed a great source of power. Another weapon is the doctrine of constitutional morality that has been built in the entire Constitution to protect the spirit of the Constitution. Of course, this doctrine has been interpreted in very different ways. When Dr. B.R. Ambedkar used this doctrine to protect the spirit of the Constitution, recently in Sabarimala case, Justice Indu Malhotra used the same doctrine to mean something different, not to take a very progressive outlook, rather to preserve what was there in practice, or what was a custom. So that's a different topic again. For this particular topic, judicial activism and judicial review, would like to conclude in the words of Justice Savant, that law and justice must be on talking terms. They are two sides of the same coin. To bring the rule of law, law and justice, they must be in talking terms. So until then, we will meet again in another video for a new topic. Thank you.